Morning. Can you guys hear me? Looks like maybe you can hear me. You're looking over at the camera. I'm Judge Nina DiPietro. Hi, good morning, Mr. Romero. We're going to do your magistrate hearings this morning, so when you hear your name, please step up to the podium. Before we start, if I could have everybody at Maine, doesn't look like there's a lot of you, but if you guys could all raise your right hand, and anybody else at the other jails who can hear me or see me, do you swear to tell the truth, the whole truth, and nothing but the truth? Say out loud yes if you agree with that. All right, thank you so much. When I speak to you individually, I may have to do that again just to make sure that everyone's covered, but try and get through this as quickly as possible while still giving everybody an opportunity to have their case heard. So we'll start with Matthew Cummings.
Good morning,
Hi, good morning, Mr. Cummings. All right, you're here on an out-of-state hold, but there is a bond associated with it, so it looks like it's $9,500. So you can post a bond. I have no ability to change the bond or address the bond. It looks like it might be Michigan, might be the other state. So if you don't post I'm going to advise you don't say anything about the facts of your case or anything like that.
Okay, this has happened to me 3 times. It's a lack of communication between Florida and Michigan. So I can pay this, but I can't pay $9,500. What I'm asking for is, can I post an surety bond for 10%? Give me 10 days to pay the full amount.
Sir, I have no control over this hold whatsoever. So as far as changing things, modifying any ability to post bonds, things like that, I don't have the authority to do any of that stuff. I hope it's not a communication issue. In the sense, I mean, we're showing in our system active warrants. So I'm not sure what's going on, but I don't have the ability to either release you or to change your bond or to change the terms of your bond. I don't have that authority.
I just know Judge Hurley, the last time this happened, that's what he did. He allowed me to post an surety.
Judge Hurley used to do a lot of stuff, and, I'm not really sure exactly what was going on back then. So, I can't really speak to what happened back then. Yes.
Judge Hurley might have done that at his extradition hearing, which he will have before
Judge
Bailey.
And what the prosecutor, Mr. Linder, just said is that whatever you may have been referring to as Judge Hurley modifying something or doing that may have been at an extradition hearing, but it wasn't at this type of magistrate hearing. So you're going to have an extradition hearing, and at that point in time, you can speak to the judge, and perhaps the judge can do something, I'm not sure, but it's not at a magistrate hearing, which is what you're here for today, okay?
So what they're asking for right now is $9,500, not 10% of that.
Well, I just see what's on here as far as the warrant. However, it says cash only. That is correct. So it's a Michigan bond that says cash only. So I have no ability to change that.
Okay.
All right. Good luck. Sorry.
Thank you. Judge?
Your Honor, the jail has asked for a couple of cases to be called out of turn.
Okay.
Is
that what you were saying, Mr. Romero?
The first one would be Zeke Victoria on page 17, and he declined the services of public defense.
Okay. Can you give me the last name again?
Zikria, first name Zeke, toward the end of the docket.
Okay, towards the end of the docket. Let me see what I can find here. Okay, I must have went too far. Okay, I found it. Okay, good morning, Mr. Zikria. You're here on 3 separate issues. So the first is a municipal ordinance violation, and specifically it's disorderly conduct. Based on my review of the probable cause affidavit, I do find probable cause for that offense. You also have 2 violation of probation or community control warrants. Looks like for 2 separate cases from 2015. Those are listed at no bond. And you have a hearing on January 2nd at 9 a.m. on those 2 cases. So as far as the municipal ordinance disorderly conduct, it's a $25 bond, but realistically, even if you were to post that, you won't be getting out because there's no bond holds on your felony violation cases, okay? Hold on. You can, but I'm going to advise you don't say anything about the facts of your case, your probation, anything like that. Everything is being recorded and can be used against you, okay?
Yeah, I can. Do you want me to check and see if he has a private attorney?
Did you want to say something now, or you have second thoughts about that?
I was just a little confused about the municipal bonds or the municipal warrants.
Well, it's not a warrant for municipal ordinance. They arrested you for disorderly conduct, and when they did that, they found you had these active warrants, okay? Or I don't know if they were active warrants or you were just on probation and they put a, hold on, I could take a look.
Yeah, it's under 948.
Yeah, so they showed that you were on probation. This automatically creates kind of a ticker in the system for a violation of probation, and you'll go to court for that, like I said, on the 2nd of January for the determination as to what's going on with that.
But ma'am, you said those warrants were from 2015?
No, cases from 2015. You were on probation on 2 separate cases that originated. Nope.
It sounded as if these were, to me, it sounded as if these were old warrants.
No. They're cases from 2015 that you were placed on probation and have subsequently now have, you know, no bond holds for violation of probation. You'll see your judge on January 2nd. Good luck to you. Okay.
There's no, this gentleman here suggested that I should ask for an earlier court date.
I mean, I don't have any control of when your court date is. I just read off what it is. If you have a public defender or if you have a private attorney, and I think Mr. Romero said to me you decline the services of the public defender, so if you're going to hire counsel.
No, that's not true.
Okay, well, in any event, you can, excuse me, sir, here. Frankly, it's irrelevant for what I'm about to tell you, okay?
Well, it's relevant to me because he's sitting right here lying to me.
Okay, sir, have a nice day. Thank you so much. Your court date is January 2nd. Okay, you too, sir. Okay. There was one other one you wanted to call out of turn or more?
Yes.
Okay.
Judge, it would be the last person on the docket.
Okay.
His name is David Sanabria.
Got it.
Over here advised me he has private counsel, Mr. Michael Weinstein.
Okay, all right. Do you know if Mr. Weinstein's going to come in today?
I had no idea about this, ma'am.
Okay. Well.
I'll check.
From my understanding, I got a court date on the 13th. He will be there.
Okay, you do actually have a court date on the 13th. I can confirm that. I can tell you these are ad charges, so obviously there are other things that are holding you in, and these are added to that. I don't know if you want to see if you can contact Mr. Weinstein and see if he's coming in this morning. Anybody?
I can give him a call, Your Honor.
Okay, so what we're going to do is I'm going to put this on a brief recall. We're going to see if we can get in contact with your attorney. Perhaps he's in court today on something else and might be able to run over.
He most likely is. So
yeah, we're gonna see if we can get in touch with him, okay?
All right, ma'am.
All right, so just hang tight, and as soon as we can find out yes or no if he's coming, then we'll call your case, okay? All right, any other ones out of turn? Okay, all right, so Raquel Palacio? She bonded, excellent, okay. Okay, Gail Lawrence?
Come on up. She declined the service of public defender.
Thank you. All right, Ms. Lawrence, you're here today. You have a couple outstanding capiases as well as a violation of probation hold. So as far as the capiases, the misdemeanor cases, their bonds of $500 and $4,000. Those were set by a prior judge. As far as your felony stuff, you have a capias that has a no bond hold, and I'll take a look at that and make sure that that's not something we have to deal with. Oh, it was a no-show at arraignment, so I can't adjust that at all. I have no authority to do that. That's going to be a no bond hold. And you also have a violation of probation. That's a no bond hold. You do have a court date that's on the, it looks like either the 16th or the 19th. I think maybe
It looks like the 19th to me.
Okay, I think the 19th. So you're going to go to court on the 19th and see your judge, and you can kind of figure out what can be dealt with at that time. Okay? Good luck. All right, Megan Flack.
North Broward.
Good morning, Ms. Flack. All right, you're here on 3 separate counts. The first is grand theft. The second is passing a forged or altered bill or promissory note. And the third is fraudulent use of possession of an ID of another person without consent. Based on my review of the probable cause affidavit, I do find probable cause. Does anybody want to speak to bond?
Yes, Your Honor. Just to advise the court, and I'm showing... Ms. Flack is, she's out on bond for a grand theft.
Case number?
It is 16-12625 CF10A.
Okay.
Similar situation that we had yesterday, Your Honor. There's a second count of resisting without violence where no bond was attached to that.
Got it. Okay. Okay. All right. All right. So here's the circumstances as it relates to the three cases. I'm sorry, the three charges that you're here for this morning. There's $1,000 bond on each, and I'm going to leave that the same. As it relates to your felony case that you're out on bond on, I am going to be revoking your bond pursuant to Florida Statute 903.0471. So when you're arrested and you're let out on bond, one of the conditions is that you can't be arrested for something else after that. So that's a violation of your bond terms. Now, Mr. Linder, to be clear, there's two counts. One she's out on bond on and the other she's not?
Yeah, there was just never a bond attached at first appearance
Okay.
based on the...
I'd ask you to attach a bond to it, Judge, so she continues to get time served. She does have a court-appointed attorney outside the public defender's office,
Okay.
George Paladis. I'll give him a call for you later, Megan.
Okay. All right. So let me explain what's going on, Ms. Flack. So because I'm revoking your bond on the other case, you're going to be held no bond. Now, originally when you posted bond and got out for that case, you had two counts. One you had to put a bond up for, actual money for, and the other one that didn't require any bond. If I only revoke your bond on the count that you had to post the bond, then you're not going to get any credit for the time that you're serving towards any potential sentence, if there would be one, on the second count. So what I'm going to do is I'm going to revoke bond on both counts so that you get credit for the time that you're doing in. This can be later addressed by your division judge. You can talk to your attorney, see if your attorney can file a motion or get you before the judge. But for purposes of this morning, your bond is going to be revoked on case 16-12625 CF10A on both counts. All right, good luck to you, ma'am.
Your
All right.
Honor, whatever you want to deal with first, we have the Spanish interpreter.
Oh, great.
And we can also, I spoke with Mr. Weinstein. I guess when we're done with the interpreter cases, we can proceed on Mr. Sentinel.
He's not coming?
No, but just information related.
Understood. Okay, all right. Good morning. How are you? Come on up. Let's see.
Good
Mr.
morning, Your
Romero,
Honor.
can we have the Spanish interpreter cases, and if you can give me their names?
Yes, Judge, I believe we have two gentlemen here at Maine. The first gentleman is on page 10, and his name happens to be Jairo Lazema.
Okay, give me 1 second. Let me look for that. Is that like towards the end? I don't get dockets, so.
Probably in the first half of your file.
Okay. What's the second person's name so I can, if I happen to pass that, I can grab that as well?
Let me try and find out his name right
Sure.
now. Suluaga on page, what page is this? 19, Judge.
What was the name again?
Suluaga.
Got that
page
one.
19.
Okay, I found that one, so that means I'm way far past the other one. Okay, got it. Okay. All right, and Miss Interpreter, if you could raise your right hand, do you swear or affirm that you will interpret from Spanish, I believe, Spanish to English and English to Spanish to the best of your abilities?
I do. Good morning, Your Honor. Solange Sands.
Okay, thank you so much.
You're welcome.
Okay, so is this Mr. Lezama?
¿Es el señor Lezema? Yeah.
Okay, good morning to you, sir.
Buenos días, señor.
You're here on
Good
several
morning.
counts.
Está aquí por varios cargos.
The first one is driving under the influence of alcohol or drugs.
El primero es conducir bajo los efectos del alcohol o las drogas.
The second is driving under the influence with an enhanced breath of over 0.15.
El segundo es conducir cuando tiene el aliento sobrepasado por más de 1.5.
The third is operating without a valid driver's license.
El tercero es conducir sin una licencia válida.
And the fourth is failure to register a motor vehicle.
Y el cuarto es no registrar un vehículo.
Okay, based on my review of the probable cause affidavit,
Viendo el documento de motivo fundado,
I do find probable cause for those counts.
veo que hay motivo fundado para esos cargos.
As it relates to bond,
Y en lo que tiene que ver con la fianza,
the first charge, the DUI, is $500.
para el primer caso, el primer cargo, el del DUI, es la fianza $500.
On the second count,
Para el segundo cargo,
I'm setting your bond at $2,500,
le doy una fianza de $2,500.
and that's based upon the allegation that your breath readings were over 0.3.
Y eso es porque su aliento parece que se midió a más de .3.
As far as the operating without a valid driver's license and failure to register,
En lo que tiene que ver con el conducir sin licencia válida y no registrar el vehículo,
I'm not requiring any bond to be posted.
ahí no voy a pedir que se tenga que pagar una fianza.
So that would be a total bond of $3,000.
Así que su fianza total sería $3,000.
Mr. Reedy, want to interject or no?
No, Judge.
Okay.
I don't know if Mr. Romero has anything to add, but I do not.
Judge, the only thing I'd be asking for is if the state can confirm, I believe this is his first exposure to the criminal justice system.
If this is the one I recall, is this the one where he was? All right, confirm it if you can.
Se pide que el Estado confirma si tiene antecedentes. Parece que no.
I have nothing in my system for him, no type of ID record, nothing.
No se ve nada en el sistema ni ningún tipo de identificación.
So the state did confirm there's nothing in the system, Judge. My understanding is he's been residing here for 5 years, residing in Davie.
Does he have a DL on there? I don't think he might have one because it's an operating without, but we'll check.
Viendo
We're gonna
que
look for a
no hay
driver's license.
antecedentes y el señor está viviendo en Davie ya hace 5 años, trabaja en construcción.
Judge, he's going to try and contact his friend to post his monetary bond, but my understanding is friends, I guess financial resources are limited as well. We'd be asking you to leave the standard bond in place considering he has no priors.
Entonces el señor va a tratar de comunicarse con amistades para ver si le pueden pagar esa fianza, pero sí me ha indicado que los recursos económicos son limitados, por eso le pediríamos a la señoría que deje la fianza estándar y eso es basado que el señor no tiene antecedentes.
Okay, and we just confirmed that he does not have a driver's license or has never sought at least a driver's license here in Florida.
Recién confirmamos que por lo menos no tiene licencia o nunca ha tratado de conseguir una aquí en la Florida.
I'm going to leave the bond as it is based upon the breath.
Voy a dejar la fianza como la dicté, eso es por la prueba del aliento.
Sorry.
Would you sign the phone order allowing him access to his phone contact?
Yes, absolutely.
Vamos a darle una orden dándole permiso a que use su teléfono.
All right, the next one that I have is Andres Zuluaga, sorry.
He's approaching, Judge.
All right, good morning, Mr. Zuluaga.
Buenos días, señor Zuluaga.
You're here on one count of grand theft.
Está aquí por un cargo de robo de grado mayor.
Based on my review of the probable cause affidavit, I do find probable cause.
Después de revisar el documento de motivo fundado, veo que hay motivo fundado.
Does anyone want to speak to bond? It's right now set at $1,000.
Vamos a ver si se quiere hablar sobre la fianza de la parte del Estado o del defensor público. En este momento tenemos una fianza de $1,000.
Your Honor, I'm just going to request that the standard bond be left in place.
El Estado pide que se deje en la fianza que se ha dictado.
Because as mentioned in the report, it appears Mr. Zuluaga has little to no ties to the community and does not reside in the country.
Y eso es porque basado en el informe vemos que el señor no tiene vínculos en la comunidad y no parece que vive aquí en este país.
Okay, well, I'll leave the bond at $1,000.
Así que la dejo la fianza en $1,000.
And Mr. Zuluaga, if you're able to bond out, you still have to come back for court if they file charges against you.
Señor Zuluaga, tenga en cuenta que si puede pagar su fianza y sale, igual tiene que regresar para enfrentar estos cargos.
All right, good luck to you.
Buena suerte.
All right, I don't think we have any more, but can you do a quick announcement to see if anybody at any of the other jails needs a Spanish interpreter?
Yes, I'll be happy to, Your Honor. Por favor, si alguien más necesita los servicios de la intérprete de español, ponerse de pie o avisar.
All right, hearing nothing, thank you so much. Thank you for coming today.
You're welcome, Your
Have a
Honor.
nice day.
You too, thank you.
Okay, and so we're doing the recall on David Sanabria.
I think he just stepped out right now to the restroom. Hold on one moment.
Okay, do you want to just let me know when he comes back then?
I will.
Okay, all right, Sharoni Pendergrass? Pendergrass?
approaching, Judge.
Thank you. All right, good morning to you, ma'am. You're here on one count of grand theft and one count of resisting an officer or obstructing without violence. And based on my review of the probable cause affidavit, I do find probable cause. As far as bond, right now the bond is set at $1,000 on count 1 and no requirement of bond on count 2. Does anyone want to speak to that?
Judge, she advised me that her aunt will be posting her bond. She gave me your phone number and I'll be contacting her after court.
Okay, all right. I'll leave the bond at $1,000 then. Good luck to you, ma'am. All right,
Mr. Senator has been brought back.
Okay.
And Your Honor, can I approach?
Yeah. Thank you.
Your Honor, I spoke with Mr. Weinstein. Unfortunately, he is nowhere near the courthouse. He won't be able to make it, but I went over with him everything that I was going to tell you. He has no objections. He will be at the arraignment tomorrow and before Judge Lynch, and any issues with bond he'll bring up before Judge Lynch.
Okay.
Your Honor, what I provided, actually, what we're hearing today, the first 2 counts are change of charges.
Okay.
And the second 2 counts are add charges.
Okay.
What I was going to be asking on the ag assaults, as you can see from Judge Halal's original findings,
Right.
she actually found probable cause for ag assault. She wrote it in.
Okay.
And since that's what has been filed, I'm just asking that the $10,000 bond she set be placed back on him on those 2 counts. And I was just going to be asking for $2,500 bonds on each of the Bat Leos. Also noting he's currently, as you can see, he's being held no bond. Judge Halal wrote on there that she revoked bond on the, it was the charge number 5 there. That originally was a bond surrender. That was a possession of cocaine.
Okay.
So he's being held no bond on that right now. Anyway.
So what, and I see here her notes, it was $10,000 per count on the ag bat.
Yes.
On the 2 ag.
Well, she found for ag assault, and that's what they are now.
Oh, I see. I understand. I see it right there. Okay. And then she set $10,000 bonds on those. And then as far as the 2 ad charges, are those on here as well?
Well, I provided, no, those
weren't.
were ad charges.
Right,
and
got
that's
it.
why if you wanted to read, I provided
Got it.
a report.
Okay, let me take a look at that. Thank you. All right, so we're just trying to figure this all out. Right now, you have already been held no bond on another case, and my understanding is you have a court date tomorrow, which your attorney is going to be present. He advised the prosecutor here in the courtroom that he's coming tomorrow. So these are things that might even be able to be spoken with about the judge perhaps tomorrow. I'm not sure. You'll talk to your attorney at that. As far as the counts that you're here on this morning, the first 2 are aggravated assault on an officer or a firefighter or EMT. Those are change of charges. So originally you had come in on a aggravated battery. The judge, it was Judge Jennifer Halal, she found probable cause only as it related to the ag assault, and the state attorney's office did actually file the 2 ag assault charges. So those, Judge Halal originally set a $10,000 bond. I'll reinstate the $10,000 bond on those. On each of those. As it relates to 6 and 7, so add charges, there is one for, let me see, this is the change, okay, so there's 2 counts of battery on a law enforcement officer that are being added to your list of charges that are pending right now. And I'm going to take a look at these. The prosecutor has requested, what, $2,500 on each? Is that what you said? All right. I'm just going to take a review of your affidavit from the police officer regarding the incident so I can understand. All right, I am going to put the $2,500 bond in on each of those counts. So it's going to be $10,000 bond on each of the aggravated assault counts, and then the 2 ad charges are going to be just a $2,500 bond on each. That's total bond in the amount of $25,000. Realistically, you're being held no bond on a separate case that you had your bond revoked. You're going to go to court for all these things tomorrow, so you can talk to your attorney about the bonds, you can talk to your attorney about the case tomorrow and see what that judge is willing to do. Okay? All right, good luck to you. Oh, sorry about that. Thank you so much. Okay, next case is Marcellus Thomas.
If I just write out on a post. Okay, right there.
Okay. All right, good morning to you. You're here on 1 count of grand theft, 1 count of committing theft or resisting a loss prevention officer. 1 count of resisting or obstructing an officer without violence. 1 count of aggravated fleeing with injury or damage. 1 count of leaving the scene of an accident or a charge similar to the 1 count of reckless driving involving damage to person or property, driving with a suspended license as well, and no proof of insurance. Let me just see here. Do I have another sheet here? Because I'm showing a VOP. Okay, and then also you have 2 separate cases where you have violation of probation charges that are holding you in no bond. Based upon my review of the probable cause affidavit, as it relates to everything with the exception of the violation of probation, I do find probable cause. As it relates to the violation of probation, I don't have to make that finding. As it relates to the bonds that are listed here, we have some bonds that are listed, and I'm going to hear from Mr. Romero as well as the prosecutor regarding bond amounts. So why don't we start with that as far as Mr. Linder, what is your recommendation for bond?
Your Honor, I'm fine with the standard bonds on count 4 based on the allegations that she is on probation for 2 separate felonies. And
when you say standard bond, there's no more standard bond on it.
No, I meant on the other charges.
Oh, okay, got it.
Yeah, I'm fine with the standard bond on all the other charges.
Understood.
On count 4, I'm asking for a bond in the amount of $5,000, Your Honor, noting, in addition to the cases she's on probation for, she's already been convicted of a theft this year. She had a grand theft 2011, theft 2011, theft 2011.
Okay.
Nothing further, Your Honor.
Mr. Romero?
Judge, speaking of Ms. Thomas, unfortunately, she's working right now at Dunkin' Donuts. She's a single mother. She has 2 children, newly born. Judge, right now her financial resources are quite limited. However, I know on count 9 and 10 she is being held no bond. Judge, I'd ask you to consider setting on count 4 $1,000 bond.
Okay. Well, based upon the allegations in the probable cause affidavit, there could have been people that were injured, and so I'm concerned about that. What I'll do is, realistically, it's kind of an academic exercise here since she's being held no bond. I'm going to set the bond at $2,500 on count 4. Count 1 will be $1,000. Counts 2 and 3 will be $100. Again, count 4, $2,500. Count 5, $25. Count 6, $100. Count 7, $25. But realistically, she's being held no bond on the violations of probation. She will see her judge on the 14th for that at 8:30 a.m. for a first VOP.
Judge, I'm just inquiring, as far as the VOP, do you know which judge is in front of?
It's Division FI. Who has FI now?
That's Judge McCarthy.
Judge McCarthy.
Judge McCarthy.
Yep.
And we'd ask you to sign an order allowing us to photograph her injury.
Sure, no problem. That's granted. All right, Susan Murray.
She's approaching, Judge.
All right, good morning to you, Miss Murray. You're here on 1 count of possession of cocaine and 1 count of probation violation or community control violation. As it relates to the possession of cocaine, I do find probable cause based on my review of the probable cause affidavit. The bond is set at $1,000 for that. Unfortunately, though, you have a no bond hold on your violation of probation. You will be seeing your judge on the 19th at 8:30 a.m. for the violation of probation. All right, good luck to you, ma'am. Oops, sorry. All right, Taylor Rivera.
She's approaching, Judge. She declined the services of public defense.
Okay, thank you. All right, good morning, Ms. Rivera. You're here on 1 count of unlawful possession of personal identification of another, 5 or more. Based on my review of the probable cause affidavit, I do find probable cause. In fact, I think it was actually 17, if I recall. 17 different names, social security numbers, and personal identification. Based, like I said, based on the review of the probable cause affidavit, I do find probable cause. I understand you've declined the services of the public defender, and that's fine. The standard bond on this is $1,000, but based on the fact that the allegation is that there were 17 different identifications taken, and it was from a place that the allegation is that it was an assisted living facility. I am going to increase the bond from $1,000 to $5,000. I can swear you in if you'd like, and you can talk to me about bond if you want to raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I don't want you to talk about the facts of the case, okay? Everything is being recorded, and they can use that against you. Do you want to talk to me about the bond?
Yes.
Okay. What would you like to tell me about bond?
Well, I have 2 children, a 9-month-old and a 2-year-old. I am a mother. I have a job.
Working where?
Well, I just lost it.
Okay.
Clearly. And I've been here my whole life, and this is my first time.
Because one of my conditions is actually not working.
Sorry, give me 1 second. State, can you confirm if this is her first offense?
Yes. Your Honor, and while I recognize she has no criminal history, I am going to be asking for a $2,500 bond based on, I believe, the amount of ID cards or personal ID she was accused of taking is an aggravating factor. In addition to whatever bond the court deems appropriate, I'm going to ask for an additional condition that Ms. Rivera may not work in any capacity at any assisted living facility until further order of the court.
Okay. Well, I'm going to leave the bond at $5,000. My concern is this, is that while she was at work, she's accused, and you haven't had a trial yet. There's no conviction or anything like that, but she's accused of taking that information from her job. So she was entrusted.
No, Your Honor, and I'm sorry, I didn't realize you'd set it at $5,000, so
Yeah.
I wasn't.
That's fine. I'm going to leave the bond that I set at $5,000, and you know, someone can post that to you. I'm not going to put in the restriction that you not work at an assisted living facility. Realistically, there's so many places that you would have access to someone's personal information other than that, so I don't know that that restriction in and of itself would do much to prevent you from doing this again, potentially. So I'll leave the bond at $5,000 with no other restrictions. Good luck to you. All right, Takesha Williams.
Hey, good morning, Judge.
Thank you.
Good
All
morning,
right.
Judge.
Good morning, Miss Williams. You're here on 1 count of possession of cocaine and 1 count of possession of alprazolam or Xanax. Based on my review of the probable cause affidavit, I do find probable cause. Does she have priors? Is this something we could put her on pretrial for or no?
Moment. Outside of no, I know she does. I want to see what they're for.
She has drug priors out of Miami, Your Honor.
Okay. How many?
2016.
Well, no, that.
Convictions or no?
No. She had a paraphernalia conviction in Dayton, 2016. She had a possession of cocaine in Broward in 2012 where her probation was violated. If pretrial can verify and address, I don't necessarily have any objection to pretrial.
Ma'am, do you have an address that you're living at full time?
I do.
Okay. Is it the 456 address?
Yes, the only
Hold on 1 second. Hold on 1 second. Let me just say this, okay? Before you say anything else, don't talk about the facts of your case. Everything's being recorded. If you want to talk to me about where you're going to be living, things like that, that's perfectly okay.
Okay. So yeah, it's there. That's the area. That's where I'm living at.
Okay. So
That's my address.
Okay.
Mom's house. That's where my kids are.
Okay. And do you think you can go back there? You think they'll let you live with them?
Sure. I mean, see, that's the thing. I have that address and I have another one.
And the only thing I would ask is that the bond be kept in place, but pretrial be allowed to verify. And once they do verify,
sure,
then she'd be ROR to pretrial.
Okay, so here's what I'm going to do. I'm going to leave your bonds at $1,000 each in the event that pretrial cannot verify an address and get someone to agree to let you stay with them. If they can verify an address and they can get someone to agree that you can live and stay with them at that address and be supervised at that address, I'll just let you out on straight pretrial.
Okay.
Okay, so
there's no ROR or anything like that because I
not
have
at
to go
this.
to a NA.
Hold on.
I'm already ordered to an NAA program starting.
Ms. Williams, I really wouldn't say too much else if I were you right now. I think your main concern should be making sure you get an address to pretrial release, that they can verify where you're going to be staying so you can get out of jail without having to post a bond. Okay?
The only other thing we'd ask is just that drug testing and drug evaluation be part of her pretrial conditions.
Yeah, I mean, definitely drug testing is going to be part of it. As far as an evaluation, we can do that as well. So here's what's going to happen, ma'am, and I'm going to pretend like I didn't hear you say that you're court ordered to do anything at this point. But I'm going to leave the bonds at $1,000 each. However, I am going to sign an order that says that if pretrial can verify and confirm an address, that those bonds will then be converted into RORs and you can go out on pretrial. Pretrial is going to have the condition that you not only submit to drug testing, but you also submit to an evaluations for substance abuse, okay? Do you understand?
Yes.
All right, good luck to you, ma'am.
Thank you.
All right, Aranetta Sanders?
She's still on loan, Judge.
Okay, so that'll be passed over for medical reset. Isaiah White? Is that me?
Paul Ryan, Your Honor.
Oh, Paul Ryan, okay. All right, good morning to you, Mr. White. You're here on, it looks like an ad charge for a KPS on a traffic offense. Was this a, all right, it looks like an operating without a valid license. What is he in on count one?
No
He's
bond
got a
on-
no bond hold on a robbery, firearm, carjacking.
Okay. I don't know, did you have an opportunity to speak to him about, does he want to resolve this, or does
No,
he
Judge,
want to
I
just hang
didn't.
tight?
I don't want him to resolve it. He
Okay.
should not resolve it. He's not going anywhere
Got it.
anyway, so.
Okay, so what I'm going to do is this. I'm just going to leave it as the $1,000 bond. Realistically, if you're being held no bond, then you're not going to be getting out regardless of whether you post this bond. And you can go into court and speak to an attorney regarding this charge when you have your court date. Okay?
Yes, ma'am.
All right, good luck. All right, Joseph Salvo. Oh, sorry. Me? Mr. Salvo? Thank you so much. Here you go. Oh, sorry. Mr. Romero, do you have Mr. Salvo?
No, I believe he was removed for confinement status, so I don't know if confinement status is
Okay. Yeah, I was going to say, it
not
looks
even a-
like it's
not a
for, not
criminal
for a
matter.
magistrate hearing, so that would make sense. Okay, I'm not going to assign anything on this because it's taken off the docket. Okay, Nelson Pierre.
North Broward.
Nelson Pierre, Judge, we have a corrected, they booked him in on a misdemeanor cases. This is a misdemeanor violation of probation.
Okay, no problem.
Court date should be set, here's the correct.
All right. Well, we're waiting for him to come up anyways. Thank you so much.
Yeah, he's got some medical issues that might make it a little slow for him to get to the
No
podium.
problem. We'll take our time.
You saw that?
Well, I saw the DOT, I didn't see that it gave you another issue, so, and honestly, so it's like, oh. Yeah. Also.
That's okay.
Your Honor, he's moving a little slow. He's got a cane, so give me
That's
1
fine.
second.
No problem.
This way, sir. Sorry, just don't fall. Stand on the X. Get screen, please. Okay, thank you. There he is, Your Honor.
Hi, good morning to you, Mr. Pierre.
Good morning.
All right. You're here because you were picked up on a violation of probation warrant.
Yes, ma'am.
Okay. So that's going to be a no bond hold. So the judge who signed that warrant already issued a no bond hold on that, and I can't change that. But I can tell you that you're going to go before your judge on the 15th. Okay, so that would be, is that later this week? You're going to go later this week at 9 a.m., okay, on the 15th to court.
Thank you.
All right,
Judge,
good luck.
I know there's nothing you can do, but I promised Mr. Pierre I'd ask anyway. He had a stroke a year ago. Obviously, he's got some physical issues.
Right.
This is a 2007 warrant that was signed December 21st of 2007, almost 10 years ago to the day. He hasn't been in any trouble since then. I don't know how the state feels about letting this 59-year-old man out so we can go to court later this week, or if we even have the authority to do it. But maybe if we agreed, it could happen.
State?
I'll leave it in the court's discretion.
Well, I don't have discretion. I
I mean,
can't
that's the
change
thing.
it. If you
that's-
guys want to enter into an agreement, I mean, I'm not going to prevent you from entering into an agreement, but at the same time, I don't have the ability to change it myself. I think it was a failure to report, am I correct?
Yeah, it was, looks like, yeah, he never showed up to probation. Yeah, I mean, frankly, my concern is, and I'm hoping.
Well,
if
hold
he's-
on
if-
here.
okay.
I have another, it says has another VOP under a different name. Is there another VOP that's pending?
Where does it say that, Your Honor?
Or this might be from way back when, but on the second, so I see the warrant that's signed by Judge Cowart, and then on the next page where it says Broward Sheriff's Office warrants / extradition unit, the very bottom it has a bunch of AKAs, and then it says has another VOP under name Eve Bruce.
Let me check.
I don't know if that's active or that was from back then, but if this is the first time he's come in contact with law enforcement since then that might also not have been resolved.
Let me see. Yeah, I mean, there is an Eve Bruce with that case number that was placed on probation in '99 by Judge Feiner, where a VOP warrant was filed in 2000. See, my only pause is that I'm quite confident that this will get resolved ultimately when he's brought before his judge in Division MH, which I believe is Judge Pohl.
Okay.
My concern seeing all these aliases and that this warrant's been out there for so long, I would just hate to see him then not show up for his, we let him out, he doesn't show up at his appearance, and then a few years from now, we're back here again on another warrant.
Well, I mean, here's the thing. Like I said, I don't have any legal authority to change the bond. The case law is pretty clear on that. Given that doesn't sound like the state is in agreement to modify the bond.
What I could do, Your Honor, if this is okay with the court, if we could reset this to the afternoon, I can make a couple calls. That's really the best I can do right now.
Okay, so why don't we do this? Why don't we reset your case for 1:30, and the prosecutor's going to make a few calls, see what information he can find out, and then he'll reassess as to whether he'll agree to some sort of bond or release for purposes of this violation of probation.
Thank you.
All right, I'll see you back at 1:30. So we'll just reset this for 1:30. Okay. And that goes with that. All right, Joshua Simpson.
He's here, President Judge Mann. This is a municipal ordinance case.
Okay. All right, good morning to you, Mr. Simpson. You're here on a municipal ordinance case, specifically trespassing. And what do you guys do with the municipal ordinance cases, being that the public defender's office doesn't handle them?
It's up to your discretion how you want to resolve it, Judge.
Okay, all right. So here's what I can do. You can either do one of two things, okay, sir? Based on my review of the probable cause affidavit, I do find probable cause. Now, as far as the options you have, the first option is that you can bond out, and we can talk about that as far as what the bond amount would be, and then you can fight your case in court at a later date. The second option is if you want to resolve your case today, I'm willing to give you a plea offer. I'll hear about whether there's any prior record or anything I should consider, and then I'll make a plea offer to you to resolve your case. What would you like to do?
I would like to take a plea, ma'am.
Okay, all right. The prosecutor's just on the phone right now. Just give us 1 second. I'll have him run your name and see if there's anything that pops up that is he believes that I should know about before I make a plea offer, okay? In the meantime, if I can have you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, excellent. Okay. All right.
Your Honor, he has priors, so they all look like they were dropped out of Rivera.
Okay.
I don't see anything. The only thing I see is 2015 possession of a controlled substance.
Okay. So it looks like she's saying that you had some priors perhaps out of another county, but they never actually resulted in any sort of conviction on your record, and that it looks like you maybe have a controlled substance sort of case of some sort from 2015.
Right.
Okay. So what I can do today is if you want, I can time serve you, or I can, well, I'll offer you a withhold of adjudication. That means that it would be on your record, but not as a conviction. I would take judicial notice of the time that you've served, and then I would assess court costs. I don't have any choice in the matter. I'd give you 6 months to pay the court costs in exchange for a no contest plea. What would you like to do?
Take the plea, ma'am.
Okay, so you want to plead no contest?
Yes.
Okay. All right. And do you understand that you're not going to fight this charge? You're not going to have a trial? The state's not going to, or the county's not going to have to prove the case against you?
Yes, ma'am.
Okay. Are you doing this freely and voluntarily?
Yes, ma'am.
All right. So in exchange for your no contest plea, I am going to, I'll give you a withhold of adjudication plus judicial notice of time served plus court costs. You have 6 months to pay your court costs, so make sure that you speak with the clerk's office when you get out of jail to do that. Okay, and I'm also going to issue, do not go back to, give me 1 second. So it's a building, 1310 Northwest 6th Street. Don't go back there, okay?
Okay.
All right, so I'm going to put no return. All right, so make sure you stay away from that place and you're good to go.
All right.
All right, bye-bye. Scott Muncie.
Mr. Muncie, come on up.
All right, good morning to you, Mr. Muncie. You're here on, it looks like, 2 KPSs of misdemeanor charges and then 1 violation of probation for a different misdemeanor case. As it relates to the 2 KPSs, just give me 1 second. I'm going to take a look and see what the nature is of that. All right, that's probation. Do we know what the charges are from the, it's like battery and criminal mischief? What were these, ad charges?
No, it's 2 separate cases. He had an open battery criminal mischief that he didn't show up for his calendar call.
Okay,
And he
all
also
right.
was on probation for
Oh,
that.
I do have that. I'm sorry. So no show calendar call. Okay, I have no ability to change that. That's a $2,500 bond, and on the battery is a $5,000 bond. So criminal mischief $2,500, battery $5,000. I don't have any ability to change those bonds, and you also have a no bond hold based upon the violation of probation. You're going to be seeing your judge on the 14th at 10 o'clock in the morning. Good luck to you, sir.
Judge, the only question Mr. Muncie has
Yeah.
is the count 1 and count 2, the battery and criminal mischief. When was the date of the alleged incident?
That I'm not sure. I can tell you what we have on the warrant. Hold on here. Well, I can tell you it's a 2017 case, so it was at least filed. Do you have the date?
I can get that. Yeah.
Okay, we're going to get the date. Looks like there was a KPS that was issued when there was a no-show at calendar call, so the KPS was issued on November 13th.
According to the information, the incident allegedly occurred August 17th of this year.
August 17th of this year for the battery and the criminal mischief. All right, good luck. All right, Michael Wedding.
He's approaching, Judge.
Okay. All right, good morning, Mr. Wedding. You're here on one warrant, KPS on a misdemeanor case back from 2007. Let me take a look. It looks like it is a operating without a valid driver's license. Yeah, operating without a valid driver's license. Does he have a valid driver's license now? Let me take a look.
It's expired.
But did he get one?
I'm just looking.
Eventually? I have it. Let's see. He did get a license.
Did he?
Yeah, well, it looks he got one, like you said, it was issued back in 2007 and expired in 2013, but he actually did have a license. Okay. All right. Mr. Wedding, if you want to resolve your case today, I can do that. I don't know if you had a chance to speak with the public defender about that.
We did.
Okay. All right. Do you want to resolve your case, or do you want to try and fight your case in court?
Yes, ma'am. I'd like to resolve it.
All right. If I can have you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Give me 1 second. Let me take a look at your... All right. Looks like he has 2 prior DWLSs out of Lee County from 2007 and 2011. Well, you're lucky that they charged you with a operating without a valid license versus a driving while license suspended, because this is a lesser type of charge. If you want to resolve your case today, I'll offer you a withhold of adjudication plus recognition of your time served, as well as court costs, 6 months to pay the court costs. Is that what you'd like to do?
Yes, ma'am.
All right. All right, so do you understand that you're not going to have a trial? You're not going to fight these charges if you resolve the case today?
Yes, ma'am.
Okay, and do you understand that the public defender is not going to file any motions or anything like that as it relates to the reason for the stop?
Understand, ma'am.
Okay, and are you doing this freely and voluntarily?
Yes, ma'am.
All right, you want to plead no contest?
Yes, Your Honor.
Okay, so I'm going to accept your plea of no contest and find it freely and voluntarily given. I'm going to give you a withhold of adjudication, meaning it's on your record but not as a conviction. I'm going to assess court costs. You're going to have 6 months to pay that. And I'm going to give you recognition for the amount of time served that you've served in since you got arrested on this, okay?
Thank you, Your Honor.
All right, pay your court costs. Okay, Camilo Garcia.
I've been advised she bonded, Judge.
Okay, great.
Or he bonded, sorry.
Wonderful. Okay, Brian Johnson. Let me see what we have here.
These are municipal ordinances.
Okay, thank you so much. All right, Mr. Johnson, good morning to you. You're here on two separate capiases. They are municipal ordinance offenses, loitering and urinating in public. It looks like one is from 2015 and one is from 2017. All right. So as it relates to the urinating in public, that one is the 2017. You have a $100 bond that was set by your judge for no showing at arraignment. You didn't come to court when you were supposed to. Also, there is a no-show from 2015 on the loitering case. That's a $100 bond as well. Do you want to resolve these cases today, or do you want to fight them in court?
Yes, I do.
Okay. All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. Does Mr. Johnson have any priors other than these two open cases that I should consider?
Old case from Palm Bay, looks like prostitution case out of Palm Bay.
Hold on, I can't hear you because it's so loud, sorry.
Prostitution out of Palm Bay.
Okay.
Another prostitution, 2001 out of Rabat.
Any convictions?
Convictions, 2001, another prostitution conviction. Was it possession of cannabis, 92, withheld?
Anything like more recent convictions? All right, if you want to resolve your case to these municipal ordinances, what I'll do is I'll adjudicate you and give you credit for time served, as well as assess you court costs on each of the cases. Is that what you want to do?
Yes.
Okay, and you understand that by doing that, by entering a plea, that you're not going to fight the case, there's not going to be any further hearings on this?
Yes.
And I don't know if I swear you in. Raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, great. We'll get past that. All right. Are you doing this freely and voluntarily, or is anyone forcing you to enter this plea today?
Voluntarily and freely.
All right. What I'm going to do is I'm going to accept your plea of no contest. I'm going to, on the two separate cases, I'm going to, on both cases, adjudicate you guilty and enter a requirement to pay court costs. You'll have 6 months to make those payments. This is on both cases, so you'll have two separate cases to do that, and I'm going to give you recognition for your time that has been served, okay? So that'll resolve both cases today.
Thank you.
All right, good luck.
Your Honor?
Yes.
If we could call a case out of turn,
Yes.
I have a witness present.
You got it.
Jalen Matire, he's on page, let's go, 14.
You guys know that I don't have a docket.
Oh, it's not just for you, Judge, it's also for people in the jail.
All right. I'm not the only one here, I guess, huh? All right.
Mr. Mateo is here, present at main judge.
What's the last name again?
Metayer, Metayer.
Maybe I passed it. I don't have that.
It's a carjacking, robbery, firearm.
I remember seeing that. I remember reading that, but hold on, it might be stuck. Oh, got it. It was stuck. Okay. All right.
And, Your Honor, just to let you know, I was hoping to provide the court with some testimony before the court makes any legal determinations.
Okay. All right. Good morning to you, Mr. Mateer. You're here on one count of carjacking with a firearm or weapon. You're also here on one count of robbery, firearm. And it looks like we have a witness here that's going to give a little bit of testimony. So if you can just kind of listen. As it relates to probable cause, I can certainly make a finding based on my review of the probable cause affidavit that I do find probable cause. All right. So let's proceed. Mr. Linder, you wanted to call a witness.
Yes, Your Honor. If this is Detective Sokol, if you could just be placed under oath.
Of course.
Good morning.
You swear to tell the truth, the whole truth, nothing but the truth.
Yes, ma'am.
Okay.
Detective, could you state your name for the record?
Detective Sokol with the Broward County Sheriff's Office Robbery Unit.
And how long have you been a detective with this unit?
With the robbery unit?
Yes, with the robbery unit.
Approximately 2 months.
And how long have you been a detective at BSO?
Almost 17 years.
Okay. And were you assigned to investigate a alleged carjacking with the firearm and robbery with the firearm that occurred in Lauderdale Lakes on December 10th?
Yes, sir.
And as a result of your investigation, Jalen Matire was arrested for these offenses?
Yes, sir.
And did you conduct an interview with Mr. Matire?
Yes, sir.
Was Mr. Matire given his Miranda rights before? Sorry, go ahead.
No, absolutely, yes, sir.
Okay, and was there any recording of the video?
Yes,
I mean,
sir.
of the interview?
Yes, sir.
Video, audio?
Video.
Okay. But there was obviously audio?
Oh, I'm sorry, video and audio.
Okay. And it's mentioned in these reports that Mr. Matire did make admissions to these offenses.
Correct.
Now, with regards to the carjacking with firearm or weapon, was there, what if any identification was made by the alleged listed victim?
The deputies on scene did a show up with the victim, and the victim 100% positively identified Mr. Mateo as the gunman that carjacked the victim.
And the alleged victim gave a sworn statement, as far as you know?
Yes, sir.
And was the statement consistent with the allegations contained in the probable cause affidavit?
Yes, sir.
Okay, and then it is mentioned that thereafter, an alleged robbery with a firearm was committed on 41st Street in Lauderdale Lakes. You investigated that offense as well?
Yes, sir.
Could you please tell the court approximately how long after the carjacking did the robbery with the firearm take place?
It was approximately an hour and 15 to 20 minutes from the alleged armed carjacking case.
And you questioned Mr. Matire as far as this incident as well?
Yes, sir.
And Mr. Matire confessed to driving?
Judge, I have to at some point object to leading questions.
Okay, I'll sustain that.
Okay. Could you please, are you familiar with the probable cause affidavit that was prepared for the robbery firearm offense?
Yes, sir.
Okay. And could you please advise the court what evidence did you obtain that led you to making the arrest of Mr. Matire, or charging Mr. Matire with the robbery of firearm as a principal?
Mr. Mateo stated to me in the interview he was the driver of the car, that he drove the vehicle. The two subjects exited the vehicle. He came back running approximately 5 minutes later with a purse, entered the car, and he fled with the vehicle as the driver, going through the intersection of 41st and 441, where he T-boned a innocent victim, which was a female and a 1-year-old child in the car.
I have no further questions, Your Honor.
Okay, is Mr. Romero or Mr. Reedy, either of you want to ask questions?
Your Honor, I would object to any cross-examination at this point, only because the probable cause, or in this case, the proof evident and presumption great determination at first appearances is a non-adversarial hearing, and really the only evidence for the court to consider for first appearance purposes is the evidence provided by the state, just like in a probable cause affidavit.
Your response, if any, to that?
I believe that's correct. Although I have been known to ask a few questions anyway of Detective Sokol this morning. I do not, but I do have argument related to potential bond issues on this case.
Okay, all right, well, let me hear. Is there any further testimony in relation to the state's position?
No, Your Honor.
Okay, all right, thank you so much.
Thank you, ma'am.
All right, state's position, and then I'll hear from Mr. Reedy.
Your Honor, state would argue now, based on the probable cause affidavits and Detective Sokol's testimony, that there is proof evident or presumption great for both counts. Mr. Matire was, as far as the carjacking, Mr. Matire was identified by the victim as one of the gunmen that committed the offense. Short time later, approximately according to the testimony, hour and 20 minutes, he was in possession of the vehicle that was the subject of the carjacking. Additionally, Your Honor, as far as the robbery firearm, he admitted he drove his co-defendants to the scene where the robbery occurred. He saw them running back to the car with a purse, noting that I believe his co-defendant, based on the name that's given here, is male. Also, I think there is proof evident presumption great that he acted as a principal, considering based on the evidence they just previously committed an armed robbery offense before committing the second robbery firearm.
Okay, Mr. Reedy.
Your Honor, if the state is asking this court to make a finding of proof evident presumption great, that is the highest standard that we have in the criminal justice system. It's higher even than proof beyond and to the exclusion of every reasonable doubt. In order to achieve that standard, the defense's position would be that the state has not introduced a sufficient amount of evidence. We heard Detective Sokol testify that Mr. Mateo gave a statement to him regarding his involvement in both of these incidents. But they have not played that statement for the court. All we have is Detective Sokol's testimony about it. I don't think if they're asking to hold an 18-year-old person in jail with no bond, that it's too much to ask that this court have an opportunity to review Mr. Mateo's statement. No witnesses have been called other than the detective who didn't witness the crimes himself, and from what I gather from Detective Sokol's testimony, he was not present when these identifications were allegedly made by the victims in the cases. So we don't have that either. We don't have the officers who did witness these identifications. The state has introduced no physical evidence whatsoever and has not called any witnesses to the actual crimes. Our position would be that that is insufficient for this court to make a finding of proof evident and presumption great, and we would ask that the court does not make that finding and sets bond for Mr. Mateo in these matters.
Okay. All right. Well, considering all of the argument, the testimony, as well as the probable cause affidavit, I do find that proof is evident and presumption is great as it relates to each of these separate allegations, the carjacking with a firearm and the robbery firearm. And on both counts, I am going to be holding you no bond. This is without prejudice for you to file or have your attorney file a motion before your division judge and have that be addressed at an Arthur hearing. But for today's hearing, you're going to be held no bond. All right. Good luck. Okay, Derek White? Thank you. Derek White?
White? Yep. Oh, Judge, I've been advised Mr. Derek White bonded.
Okay. You wouldn't have had to made it because I found it too, but for purposes of letting him be on bond, it's going to stay. Oops, sorry. Okay, Jeffrey Courtney.
I've been advised to bonded as well, Judge.
Okay, no problem. Tommy German.
Mr. German is here, present Judge of Maine.
All right. Mr. German, good morning to you. You're here on one count of petty theft, second-degree first offense, and one count of obtaining groceries with intent to defraud. Based on my review of the probable cause affidavit, I do find probable cause. Let me see. Was there a recovery? Yeah.
Yes, there was, Judge.
Yes.
It
definitely of the items he brought back to try to...
What's that?
I said definitely the items he brought back that allegedly he tried to exchange for money, credit. The allegation, Your Honor, it's basically two separate acts.
Oh, I see. Return for it. Got it. Okay. I see where it says return them. All right. What are his priors?
Your Honor.
And is Walmart one of the ones where they're sticklers?
No, actually.
Or is that Target? I forget.
Maybe it's. I don't know.
I know one doesn't permit diversion from back in the day.
Yeah. 2012 Grand Theft Auto, 16 months state prison. Delivery of cocaine, burglary of a structure, resisting without violence in 08. 15 months state prison. I don't know that he would qualify necessarily.
Not qualifying for a program. All right, Mr. German, if you want to resolve your case today, I'll extend an offer. Otherwise, you can bond out and you can fight the case in court. What would you like to do?
He advised me, Judge, he wanted to try and resolve this case today.
All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. All right. As it relates to both of the cases, given your criminal background, I will be extending an offer of an adjudication. That's a conviction on your record, time served, and court costs as to both counts. You'll have 6 months to pay the court costs. Is that what you want to do?
Yes, ma'am.
All right. And that would be a plea of no contest. Is that correct?
Yes, ma'am.
All right. And in exchange for your plea of no contest, you understand that you're not going to be fighting the case. You're not going to have any further hearings or a trial?
Yes, ma'am.
All right. Are you doing this freely and voluntarily? Is anyone forcing you or making you do this?
No, ma'am.
All right. I'm going to accept your plea of no contest to both counts. I'm going to assess an adjudication plus time served plus court costs and 6 months to pay. Make sure you pay your court costs, okay?
Yes, ma'am.
All right. Good luck. All right. Ramon Gonzalez.
Still on loan, Judge.
Okay. Yes, both counts. Both counts. All right. Colton Viger or Vigor?
He's in Conti, Judge.
All right, good morning to you, sir. It looks like you have an ad charge here. It is a felony capias. Let's see. Not in custody capias. Okay, so it is for one count of robbery, son, and snatching with no weapon. As far as the warrant obviously provides, or there was a not in custody capias, that's probable cause. I think this is a bondable offense, so I think I have to set a bond on this.
Yes, Judge.
All right, so let's figure out what we're gonna do. Hold on,
Don't
sir.
don't talk about the case, Mr. Viger.
All right, hang on. So first of all, raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
All right, so I'm going to advise you that you probably don't want to talk about the facts of the case or profess, even if you're professing your innocence, because everything that you're saying is being recorded and can be used against you. You understand?
Yes, ma'am.
Okay. With that being said, I am going to set a bond on your case because this is a bondable offense and there was a no bond hold that was issued. So as far as it relates to priors and recommendations for bond state?
Yes, Your Honor, I'm going to be requesting a $3,500 bond in order of no victim contact. On counts 1 and 2, he is serving a county sentence on 2 separate violations of probation for misdemeanor battery. He's got a DUI property damage and leaving the scene of an accident in 2014, and a burglary dwelling in 2007 where he violated probation and was sentenced to 2 years in Florida State Prison.
Okay. Mr. Reedy, anything?
He's not going anywhere right away, Judge, but I think that bond is excessive. I'm just looking at the probable cause affidavit right now.
Okay.
It looks like they were renting a hotel room, and allegedly, according to the victim, he snatched some money from her hand and fled the room. Whether that happened or didn't happen is an issue to be decided another day. In light of the fact that he's not leaving the county jail right away, I'd ask the court for a $1,000 bond, let him make some contact with some people, get that bond money worked up, and when his county sentence comes to an end, he could bond out at that time.
Okay. All right, so state's asking for $3,500, defense is asking for $1,000. I'll give him a $1,000 bond. As Mr. Reedy said, you are already serving a sentence right now, so you're not going to be getting out. So as far as the bond, probably want to sit tight until you are closer to the end of your sentence, then figure out what you want to do with that. But it's a $1,000 bond. Good luck to you.
He also has a court date, December 14th at 8:30, Mr. Viger.
Oh, I'm sorry.
In front of Judge Siegel.
I apologize. Yeah, you're going to go before your judge on the 14th.
Yes, he'll be in front of the judge in a couple of days. Okay? All right, good luck.
All right, David Castillo.
Mr. Castillo is here, President Main Judge. He's approaching.
All right.
Sir.
All right, good morning, Mr. Castillo. You're here on one count of petty theft, second degree, third or subsequent offense. Based on my review of the probable cause affidavit, I do find probable cause. The bond is currently at $750. Does anyone want to speak to that?
Yes, Judge. And speaking to Mr. Castillo, from what he informed me, unfortunately he's homeless right at this time. However, he does have a mailing address where to receive notices. My understanding from what he told me, and he has a record, but he's been clean for the past year about. He's 33 years old, residing here his whole entire life. He's asking, Your Honor, considering this is a non-violent offense, he's asking for you to consider releasing him ROR.
Okay. Does he have prior failure to appears, and what is his prior record? Obviously, I can see there's some convictions for theft based on the probable cause affidavit. What else is out there?
Yes. One moment, Your Honor. 2013 aggravated battery, 2 separate possessions of cocaine.
These are all the convictions, or?
Yeah, he was sentenced to 2 years and a month in state prison. He was released December of 2015.
Okay.
Possession of cocaine conviction, 2016. And then the thefts that are referred to in the report, Your Honor.
All right. What I'll do is, I mean, is he going to be able to be? I'm not going to release him ROR. But as far as could he do pretrial, some form of pretrial? I mean, he says he has a mailing address. Does he have a residence where he can stay and report?
From what he advised me, he has no residence. Unfortunately, he's homeless. However, he does have a friend that receives mail for him who resides in Hollywood, and that was the mailing address he was going to use.
I mean, my only concern is based on his criminal history, the prison sentences, and, you know, as far as I understand it's not, that $750 is not a high bond compared to some of the ones we see, but I understand to him, he can't make that. So I want to put something in place that is doable, but at the same time, I am concerned about having him out. And I know I don't know how I could put someone on some a GPS monitor or anything like that if he doesn't have a place to go. I normally try and work things out with regular pretrial, but I don't think that this would be the type of offense, given the nature of the criminal history, that would be just a regular straight pretrial.
I also,
Judge,
Your
my
Honor,
understanding is also, I believe the petty thefts also are quite dated, and he has been clean for about over a year now.
and Your Honor, I can tell you, he has at least one prior failure to appear. He was arrested last December on a capias, on a felony case.
So what happened with that felony case?
He ended up, it was tampering. He ended up resolving the matter later on, but.
So he has another.
No.
conviction?
Yeah. I'm just saying, you'd ask me if he had any prior failures to appear.
Oh,
so.
yeah. Okay, so he has more criminal history as well with the tampering?
Yes, I mean, frankly, my bigger concern is that he failed to appear. And I'm suing another capias issued on an MO case last year where he failed to appear in court.
Yeah, I mean, he's definitely not a candidate for ROR. And I don't know how you can monitor someone that doesn't have a specific address on a higher level of pretrial than just standard. So, I mean, I'll reduce the bond to $250, but as far as any other type of release, I don't know that is possible. If it is, certainly, have an attorney file a motion if they can get creative and go before your division judge. For now, I'll change the bond to $250. Good luck to you. All right, Brandon Lee.
Mr. Lee is here at Main Judge. He is approaching.
Okay. All right. Good morning to you, Mr. Lee. You're here on 2 counts of aggravated child abuse. You're also here on 3 separate counts of child abuse without great bodily harm. And you're here on 3 separate counts of contributing to the delinquency or dependency of a child. Based on my review of the probable cause affidavit, I do find probable cause for all 8 counts. As it relates to bond, I'll hear from state first and then defense.
Your Honor, I'm on counts 1 and 2, I'm going to be requesting $10,000 each. On counts 3 through 5, $2,500 each. I'm fine with the standard bonds on 6 through 8. Noting, Your Honor, obviously, I'm not going to go into detail on the allegations, but that they were so severe that 3 children felt the need to run away to family members in a different county to get away from Mr. Lee. Noting he's been convicted twice in 2008 for domestic violence battery. One of those cases, he violated probation and was sentenced to 364 days in county jail. Your Honor, and I know this case wasn't resolved, but I'm noting it. In 2006, he was arrested for domestic violence battery. That was null prost. I do believe it's relevant considering that this case involves family members. That case involved a family member. Matter of fact, under the rules of procedure in domestic violence situations, the state is required to advise the court of all previous arrests, not just the cases that were resolved. He also had a 2003 possession of cocaine under the name Brandon Watkins.
Okay, defense?
Judge, if I heard correctly, I believe the priors or his last exposure to the criminal justice system, I believe it's about roughly 10 years ago. He lives in Fort Lauderdale, Judge. He's been residing in the same place for about a year and a half, him and his girlfriend. He's been residing in our community his whole life. He's 32 years old. He works for a labor pool. After taxes, he gets paid about $34 a day. He's been doing that now for about 1 year now. The alleged, children involved in this, they're in DCF's care at this point. So right now there's no sort of any risk as far as having contact. Judge, at this time, he's going to be relying on his girlfriend to help post his bond. His girlfriend is a lab technician. From what he understands, the bond that she could probably afford, we'd be asking you to consider setting a bond of $1,000 on count 1, count 2, counts 3, counts 4, and counts 5, Judge.
And Your Honor, there's additional information I was not aware of that pretrial has.
That are active?
Judge, we can't hear what's going on.
Okay, so what pretrial has said is that there are 2 active warrants from out of state. One was a failure to appear. I'm sorry, for what?
One is a failure to appear and the other is a traffic offense.
Okay, so one's a traffic offense, the other one is a failure to appear, and they're both out of Georgia, is that correct?
Yes.
Okay, so he's got 2 other active warrants out of another state. What I'm going to do is this. I'm going to grant the state's request. I'm going to issue bond in the amount of $10,000 for counts 1 and 2. So that's $10,000 each. On counts 3 through 5, I'm going to assess a $2,500 bond on each count. As it relates to counts 6 through 8, I'm going to increase the bond to $1,000 each count. And it goes without saying, no contact with the alleged victims in this case. So that's going to be a bond of $10,000 count 1, $10,000 count 2, $2,500 count 3, $2,500 count 4, $2,500 count 5. Counts 6, 7, and 8 are going to be $1,000 each. Good luck to you, sir. Okay. All right, Brandon Burke.
Mr. Brandon Burke, Judge, he declined the service of public defense.
Okay.
I have my request. Oh, Judge, he has private counsel, Mr. Michael White.
Okay. Do we know if Mr. Weiss is coming this morning? Do you have any idea, sir?
Did you say
Weiss? Weiss or Weinstein?
Weinstein.
Weinstein. Okay, well, I can tell you that Mr. Weinstein also had another client that was here this morning, and he wasn't coming for that.
And from what he told me, he's just physically nowhere near the courthouse, so I don't believe he'd be able to make it. Your Honor, considering he's got these no bond holds, I was just going to be asking for the standard bond on count 1.
Okay. All right. Well, here's what we can do. I can give you the opportunity, if you want your attorney to be here, we can call him and see if he can come to the courtroom. We actually called him for a different defendant on a different case earlier this morning, and he did not. He said that he wasn't near the courthouse and wouldn't be appearing. Hang on 1 second, okay? Just let me finish, and then I'll swear you in and we can chat. You do have a bunch of no bond holds, and let me see. Nope, he's on loan, so he's not. You're on loan, it looks like, from FDC, so it doesn't appear that you're going to be getting out. And even though these are these all out of custody? Hold on.
No, counts 2 through 7 are all failure to appears.
Okay.
He's actually.
Got it.
And he's. It looks like he's been brought down pursuant to a transport order from.
I saw that.
Yeah.
Okay, so here's what's going on. I can't change any of the no bond holds, okay? I can't even address them. So you're going to be held no bond, but we also know that even if you weren't being held no bond on those, you're not getting out of custody based on your other federal holds. As far as count 1, that has a bond that's been assessed by the judge, and I don't have a problem leaving that there because realistically it's not going to make any difference. Now, if you want, we can try calling your attorney and see if he will come to the courtroom. Like I said before, he didn't come earlier for his other client, but that doesn't mean that he wouldn't necessarily come for you. I can do that, or if you want, given the fact that I can't change any of these no bond holds, if you want to just proceed, and then you'll have a court date with your attorney at a later date.
Proceed.
Okay. All right. So based on my review of the probable cause affidavit, count 1, the fraudulent use of possession of identification without a person's consent, I do find probable cause based on the not in custody capias that was filed, as well as for counts 2 through 7, they're all capiases on felonies for failure to appears which have no bond holds. So it's $1,000 on count 1 pursuant to the warrant, and then there's no bond holds on the remainder. Okay? All right. Good luck. All right, Fandy Fluinord.
North Broward.
Thank you. Hello, sir. How are you?
How you doing? How you doing? Good.
I'm great. Thank you for asking me. All right, you're here for 2 separate counts. The first is burglary of an unoccupied conveyance, unarmed. The second is petty theft. Based on my review of the probable cause affidavit, I do find probable cause, and we're going to have a little chat about bond, okay? So give me 1 second. State what's your position on bond as far as any priors and failure to appears.
Your Honor. Wait, what? 1 moment. He's still in. Yeah. Yeah, actually, Your Honor, he's finishing. I'm going to be asking for a $7,500 bond on count 1. He's actually finishing up a prison sentence right now that's set to expire on the 15th for a robbery by sudden snatching in 2016, where he was sentenced to just under 13 months in state prison. He had a battery 2014. These are all convictions.
Okay.
Judge. Burglary, conveyance, and felony criminal mischief in 2014. 2012, a burglary of a dwelling 21 months state prison. He also, in 2010, I'm showing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 15 separate burglaries of dwellings. They were all dismissed on competency grounds. There was also other burglaries between 2008 and 2010 and a strong arm robbery that were also dismissed for the same reasons.
Okay. All right, Mr. Reedy?
Well, as the state points out, Your Honor, Mr. Florinord is just finishing up a prison sentence. He doesn't have any money at all. He's been in prison. Obviously, we're concerned about the method by which his prior cases were resolved. We're aware of that situation. We'll be looking into that.
Got it.
He has provided me with the phone number of his mother, who I'll be calling after court. As far as bond is concerned in this matter, I don't know how much money she has. I'd ask the court to consider a $1,000 bond for Mr. Florinord.
Okay. All right, what I'm going to do is this. I'm going to give him a $1,000 bond based upon the allegations that are in the probable cause affidavit. So what you're going to have is a $1,000 bond plus the $100 bond on the petty theft. So that's going to be a total bond of $1,100. You're not going to get out until you finish your prison sentence, but after that, perhaps you can post bond. Mr. Reedy said he's going to speak to your mom and see what she can do. Okay?
Okay. When she gonna speak? When he gonna speak to my mom?
He's going to call her.
I'm going to call her after court. When I get done with here in court, Mr. Florinord, I'll be giving her a call, okay?
Yes.
Your Honor, because with the $1,000 bond, then would the court consider pretrial with the GPS monitor? And the reason I'm asking that is I was reviewing his cases, previous cases before Judge Porth, and it would seem in those cases, he, on his conditional release, he would put him on a GPS monitor, have him reside at his parents' home.
Yes. An immigration hold, you said?
Well, they could drop that at any time then.
Okay. Well, as far as the immigration hold, I mean, I don't know if that's going to stay or not stay. But I do, if Judge Port's typical standards of release involves pretrial supervision, I think that would be appropriate given that I've lowered the bond to $1,000. So I will put him on pretrial release. Go ahead.
I'm being told it's really, they're not able to now with the.
No, that I understand. So if there's no further holds and he's able to bond out and to, I can't hear you. Okay, I understand that, but immigration holds are not always going to stick around. Sometimes they're released depending on the circumstances. So if he is in a situation where he is going to be released on bond for these offenses, there will also be a pretrial component. Does that make sense?
Hold on, Mr. Florinord.
If the order is specifically worded that should he be eligible release from custody, not immigration, and the immigration hold is inactive, then he would be supervised by pretrial release of the GPS.
Yeah, you guys can figure out a way to word it. I mean, I know I can order it, so we can figure out a way to word it so that, it jives with everything. It jives with the immigration hold, and it drives, with everything else. So you're shaking your head. Is there something I should be aware of? Well, if they don't drop the immigration hold, he's going to go to immigration.
Okay, well,
so it's like a back and forth.
What if I put him on regular pretrial versus a GPS?
Well,
okay, we all can recognize that if he has an immigration hold and he's sent somewhere based upon the immigration hold, then he is not in violation of any sort of pretrial orders, things of that nature. So,
Your Honor, I don't. Balancing the interest, I don't think it would be that great an inconvenience that if there comes a time where immigration is ready to pick him up, to bring him in front of his judge, have that explained, and have the conditions deleted.
Yeah, I'm going to leave it. I mean, if I know he has an immigration hold, then there's a potential that he could be going elsewhere. And I'm sure that this is not the first time that this has been dealt with through the jail or confinement status or whoever it is that has to deal with those issues. I'm sure we can find a way to word an order that, you know, that can satisfy everybody's needs. I'm not saying it's not complicated, but you know, a lot of times we deal with complicated things here, and we find a way to make it work, and so that's what I'm looking to do. So I'll put him on regular pretrial if the GPS monitor is going to create an issue more so than anything else.
Well, I don't think it. I frankly don't think it would, Your Honor, only because, as confinement stated, all that would be needed, all that they would need to do, or PD, whoever's representing him, file a motion in front of his judge, get him right in front of his judge, Your Honor. We've been advised immigration's ready to pick him up. They can't with the GPS. But the court waived the pretrial GPS so he can be picked up by immigration. Then it's done.
Well, I don't think he can, even let's say he bonds, they're not going to let him out of jail to put a GPS on him. So I don't even think that situation would arise.
It's just getting rid of the condition at that point so he can get picked up. And that's all.
But I don't even know that, okay, so you're saying that because there would be a condition, period.
Yeah, that's what's being explained.
What if we don't have a GPS monitor? What if it's just... Hey, sir, don't say anything about your case, okay, because everything's being recorded. We're trying to figure out how we can give you an opportunity to get out without it being complicated with your immigration hold, okay?
I think you'd still...
I'm trying to figure out how long ago I catch that case. I've been in prison the whole time. I've been in prison for 2 years, miss. I'm supposed to get out of prison. They telling me I got this case here.
Fandy, hang on, Fandy. We're trying to figure something out here for you, okay?
Okay.
And I'm still riding for it. I'm still getting motion for it. I've been riding for it for 2 years, all type of mess.
I don't have the paperwork in front of me anymore. Was this offense during the time he was in custody?
Oh, thank you. No, Your Honor. What happened was this allegedly occurred in January of 2016.
Okay.
Hold on, Fandy. Hold on.
All right, so, sir, they're saying that this is an offense from January 15 of 2016. So you were asking for the date.
And what happened was...
2016.
Yeah.
I was in prison January 5th, 2016.
When did you go to prison? Okay, we're going to verify that. Give me 1 second.
I've been in prison for 24,
Sir, it's probably better, because we're going to check that right now. It's probably better you don't say anything else about anything for right now. Just give us an opportunity to check. If you were in custody at the time of this, then that's something we'll consider. If you weren't in custody at that time, then that obviously gives us a different consideration. So hang on.
The DOC page, Your Honor, showing that he was incarcerated from May 17th of 2016
okay, so May.
to February 7th, 2017. Then it appears he was taken back into custody again in March. There must have been, I imagine, a violation of a release condition.
All right, but this offense is from prior to him going into custody. All right, so we've confirmed, sir, that you were not in custody at the time of the allegations of this offense. So.
In Haiti.
All right, so what I'll do is what did I put, $1,000
Your Honor, then, well, what I would request then is because of what we're being told, if the court's not inclined to put any conditions, if you would allow on the record that you're making a determination without prejudice, so, Your Honor, I can call Mr. Lynch, we can maybe figure something out the way it would need to be worded.
Okay.
And if the state, with leave to the state to seek at a later date, Your Honor. And if you just put that on the record that way.
Okay, so you're saying that I would not be putting in effect the pretrial now, but that you would later be seeking it based upon your conversations with Mr. Lynch as to how you could fashion an order.
And I don't know if we will, but if we wanted to, only because in the legal basis would be, Your Honor, obviously there would be conditions that we're not aware of at this time, and that would be how to word the order to seek these conditions.
All right. Well, let me just say this for the record, if in the event that you need to pull the transcript or the recording, that I'm inclined to put him on pretrial release. Confinement status is obviously stating that this is a complication as it relates to the immigration hold. And so at this point in time, we're going to try and figure out if that's something that can be worked around through an order. If it is, the state's going to seek that at a later date and time and present those conditions to a judge and explain to them what they've learned as far as after speaking with counsel for the jail. Or for, I should say, the sheriff's office. Hang on, sir. For now, all right, sir. I confirmed, because that's important to me, because if you were in custody, that makes a really big difference, right? But we just confirmed that you weren't in custody on that date. So I did confirm that. I did look into that. Obviously, if I could see that you were in custody on the date of the allegations, that would be a different story. But unfortunately, that's not the case. In any event, I'm going to assess the bond at $1,000 and certainly note for the record that it was my intention to put you on pretrial release if you were able to bond out on that.
I got locked up the beginning 2016.
No.
Beginning 2016.
I haven't been able to confirm that, sir. Sir,
I got locked up the beginning 2016.
Okay. All right. Thank you so much, sir.
Check my record.
We did.
At the beginning 2016.
Mr. Reedy, do you show anything different?
Just sit tight, okay?
All right, sir. We looked into it. Based upon the records that I have, that's not what we're showing. Good luck to you, sir. I'm going to move on to the next case, Alonzo Russian.
Mr. Russian is here, President Judge of Maine.
Okay, thank you. All right.
Judge,
yes.
He's declining the services of public defender.
Okay.
Oh, no, yeah? Oh, no, you changed your mind.
Understood. All right, Mr. Russian, you're here on one count of burglary of an unoccupied conveyance unarmed. You're also here on one count of petty theft, second-degree first offense. And these are 2016 allegations. They are not in custody capiases. Based on my review of the probable cause and affidavit as well as the not in custody capias, there is probable cause. Let's have a chat about bond.
Sure.
State.
One moment, Your Honor.
Sure.
I'm showing a felony battery at a Daytona Beach in 2004. He received a withhold. Nothing else, Your Honor. State would be requesting a $1,500 bond on count one.
Okay. Defense. Mr. Romero?
The judge is being Mr. Russian. He's been residing in Florida his whole entire life. He's 32 years old. He's currently working. He works for a company called Cool Air. He's been there for about 1 year as an AC technician. He makes approximately $13 an hour. He lives with his mom in Fort Lauderdale. He helps his mom with the expenses as far as the rent, the utilities. His portion of the share is about half, $600 per month. At this time, from what he informed me, he really has no sort of savings. He's going to be relying on his mom to post his bond, but from what he thinks, she can probably afford only a $1,000 bond on count one. So that's what we'd be asking you to consider at this time, Judge, $1,000 on count one and leave the standard bond in place for count two.
Okay. Based on the fact that he has very little criminal history and that this is an offense from 2016, not in custody capias, I'll give you a $1,000 bond on count one and $25 on count two. Good luck. Okay, Nicholas Register.
Mr. Register is here at Maine. He is approaching, Judge.
All right, good morning to you, Mr. Register. You're here on one count of possession of methamphetamine, one count of possession of drug paraphernalia, and a misdemeanor capias from 2017. For the misdemeanor capias, you have a court date on the 18th at 1:30 p.m. As it relates to the other two counts, I do find probable cause. The bond right now is the $250 bond on the misdemeanor case, and that is... looks like possession of drug paraphernalia. And then as far as the other two, I'm inclined to either put them on. Is the capias?
Your
is
Honor,
it a not? What's the deal with the capias?
It's a failure to appear.
Oh.
And in addition to that, he has a separate pending drug paraphernalia that he was just, that it looks like it was downfiled from a felony. I'm not sure, but he has two open possessions of drug paraphernalia. He just resolved another paraphernalia June of this year. I'm not sure. He might be on probation also for battery.
Okay. Is he on probation?
One moment. No, it looks like what happened was he was placed on. Okay, he resolved a domestic violence battery last year, and he got 118 days time served. But it just seems like, he's not getting the message. I mean, this will be 3 open cases right now.
Pending case? Well, we know that 2017 is a failure to appear.
Yeah.
And he has the new allegation. Is there another pending case?
Yes, there's another drug paraphernalia that is also.
Is he out on bond? What's the deal with that?
Let me see. Oh, wait, one moment. Wait, hold on. Okay, 2 things. One, Your Honor, as far as the battery, I put in the wrong case number. He was on probation for battery resisting without violence. He violated his probation and it got jail time for that.
So that's resolved, though.
Yes.
Okay.
The other drug paraphernalia. It started out as a possession of methamphetamine and drug paraphernalia. He was ROR'd. We declined the methamphetamine and filed the drug paraphernalia. So he's got 2 open paraphernalias.
All right. What I'm going to do is this. I'm just going to leave the bond at $1,000 on count 1. No requirement for bond on count 2. $250 on count 3. You're going to go see your judge on the 18th. So even if you are able to bond out, you have a court date on the 18th at 1:30. Good luck to you. Okay, Curtis Hoffman.
Yes, ma'am.
Wait, hold on here. Go ahead.
Mr. Register is asking me if Your Honor would consider reducing the bond amount on count 1. There's no way he can potentially afford to post the monetary bond of $1,000. My understanding, I believe in the reviewing the PC affidavit, this is a residue case. I believe the same thing's going to happen. The felony offense is going to probably be declined and it's going to be resolved as, it's going to be filed as a misdemeanor. I'd be asking at the very least, if Your Honor's not inclined to ROR, if you would put the standard bond on the paraphernalia charge of $100, reducing it from $1,000 to $100.
While I can appreciate your arguments, he has a pending open case right now that I'm not revoking bond on. So I'm going to deny that request and leave it as is. All right, Mr. Curtis Hoffman.
Yes, ma'am.
North Broward, Judge.
Thank you so much. All right, Mr. Hoffman, good morning to you, sir. You're here on 1 count of violation of probation for a felony.
What was the violation, ma'am?
Hold on. Hey, sir, I'm going to advise you not to say anything. Everything you say is being recorded, and they can use it against you. So
okay, ma'am. I understand, but I didn't do anything of violating.
Well, you have an active warrant, so that's what the problem is. So the warrant...
Curtis, the allegations are that you changed your address without permission, just what we were talking about earlier.
Okay, so you have...
All
right.
I know. Don't talk anymore about it. You're going to be going in front of your judge in a couple of days. You'll be able to explain it there in front of Judge Porth.
Here's the thing. Today's the 12th. You're going to court on the 14th. So you're just going to have 2 sleeps until you go see your judge, and you're going to be able to go talk to him about it, okay? So I can't change anything about your bond. It's a no bond hold. I don't have any authority to do that, all right? Good luck, sir. All right, Mr. Edward Willis. What'd you say? Me. Got it. Thanks.
He's here.
Hi, good morning to you, sir. You're here on 1 count of a violation of probation for a felony case, a 2016 case. So you have a no bond hold. You're going to go see your judge on the 18th at 9:00 a.m. Good luck to you. All right, Donald Carter.
North Broward.
All right, good morning to you, sir. You're here on 1 count of grand theft, 1 count of resisting an officer or obstructing without violence. You have 2 probation violation or community control cases. You also have leaving the scene of a crash involving damage or damage to property, as well as 1 count of driving while license suspended. Based on my review of the probable cause affidavit, I do find probable cause. As it relates to your probation cases, you have no bond holds on that. You're going to go see your judge on the 15th, okay? As it relates to the other charges, I'm going to leave the bond at $1,000, count 1. No requirement for bond on count 2. As far as counts 5 and 6, I'm going to put a $100 bond on each of those. I don't think it's going to make much of a difference because of the no bond hold right now. But you're going to go see your judge on the 15th at 8:45 a.m., okay?
Yes, ma'am.
Your Honor, I'm going to be asking the court to be signing an order allowing our office to take photographs of Mr. Carter's injuries.
Granted. All right, Delphin Thompson.
Judge,
Mr. Thompson's approaching. He just serves the public defender.
Okay, thank you. All right, good morning to you, Mr. Thompson. You're here on one count of committing grand theft with property damage greater than $1,000 and one count of criminal mischief over $1,000. Based on my review of the probable cause affidavit, I do find probable cause. And, all right, hang on one second. If you want to talk to me about the bond, you can, but you have to raise your right hand first. No, it's okay. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So as far as the bonds, right now they're set at $7,500, count one, $500, count two. That's a total, you can put your hand down, total bond of $8,000. Can you make that bond?
All right.
And don't talk about the facts of the case, all right? Because everything you say is being recorded and they can use that against you.
Yes. Could you consider a pre-trial release?
All right, hang on. I can consider that. Give me 1 second. State what are any priors and any failure to appear. Is anything else I should know about?
I don't see any criminal history. I would note, though, just concerning to me, this did involve a theft of a vehicle with a value at approximately $125,000.
All right, well, there may be an ad charge in the future. I'm not sure. As far as pretrial release, what's your position?
Your Honor, I think because of the value of the property that was allegedly stolen, I do think some bond is appropriate. Maybe not $7,500, but some monetary bond.
Okay. All right. So, sir, if you want to talk to me as far as the bond or pretrial release, anything else you want me to consider?
Yes, just basically the pre-trial release, so that I could go out and get a lawyer and probably get back to work.
Well, let me ask you this. Hold on 1 second. I'm showing just in your paperwork, and that doesn't mean that it's accurate necessarily, but it's showing, do you live in Coral Springs?
All right. The thing is, I recently moved from Coral Springs to North Lauderdale.
Okay. How long have you lived here in Florida, though?
Like 3 years.
3 years, okay. And you moved, so the address that you gave them, that's not your address, the Coral Springs address?
On my ID, I haven't changed my address as yet.
Okay, what is your address?
My new address is 7519 Southwest 6th Street, North Lauderdale.
Okay, and what are you doing for work?
I am an electrician, technician.
Okay.
It says
all right.
For automobiles.
Right. All right. Well, I mean, here's what I can do. I can give you a lower bond and place you on pretrial. Is that what you want me to do?
Please.
All right. So what I'll do is this. I'm going to give you a $2,500 bond on count one. I'll leave $500 bond on count two. That's a total of $3,000. If you're able to bond out, I am going to put you on pretrial with a GPS monitor. So you'll have to provide your new address for pretrial to confirm and make sure they can verify the address, okay? So it'll be $3,000 plus pretrial release with the GPS monitor.
Okay.
Okay? All right. Good luck to you, sir.
All right, thank you.
You got it. All right. Adrian Kennan.
Come on up, sir.
All right. Good morning to you, Mr. Kennan. You're here on one count of possession of cocaine. Based on my review of the probable cause affidavit, I do find probable cause. Does anybody want to speak to bond?
Your Honor, one moment. I'm noting.
Is he a candidate for pretrial, or does he have priors?
He does have priors.
Okay.
2012 theft with the VOP, 180 days. 2010 delivery of marijuana for consideration. Conviction, unlawful use of false name ID, 06 conviction. Possession of cocaine, 99 with the VOP. What's that? I'm also showing he's been arrested. 1, 2. Twice in the past for failing to appear in court.
Okay. All right, sir, can you make a $1,000 bond?
Yes, he's going to be contacting.
Okay. All right, I'll leave it at $1,000 then. Good luck to you. All right, Cliffus Belfin.
I've been informed you bonded.
Okay. All right, Timothy Lee.
Yeah, I completely missed Mr. Lee, Judge. I didn't talk to him.
All right, I'll give you a chance. All right, good morning to you, Mr. Lee. You're here on one count of petty theft, second degree, a third or subsequent offense, and one count of giving a false identification to a law enforcement officer. Based on my review of the probable cause affidavit, I do find probable cause. It's my understanding that the public defender didn't get an opportunity to speak with you this morning, so we can chat about bond.
Mr. Lee, are you going to be able to afford any kind of bond for this? Right now, your bond is $750. Can you come up with that?
Uh-oh. So you have a pending case?
Yes, it's for, the bond surrender will be for $1,950. He's out on theft, fraudulent use of ID of another, misdemeanor possession of cannabis, and DWS third or subsequent offense.
Pending case?
It is pending. He was arrested. A filing decision has been made, but he was only arrested 21 days ago.
What case number is that?
So, I don't have that.
Case number 170.
Thank you.
13311 CF10.
Thank you so much. How does a bond revocation affect a bond surrender?
We're gonna bring him back in custody on that case.
Yeah,
But I mean, as far as
it doesn't. It really doesn't have an effect. Right now, as of right now, he can go ahead and post the bond again. If you revoke, he'll just be ordered to be held no bond.
Okay, well, here's
or
what I'm...
on whatever bond you said.
Yeah, well, what I'm going to do is this. Based upon the fact that you're here back again 21 days later, and you have a pending case that you're out on bond on, even though they're surrendering the bond, you'd be arrested on that, you'd be able to bond out on that. I am going to be revoking that bond to a no bond hold. So that's on case 17-13311CF10A, based on Florida statute 903.0471. So when you're out on bond, you can't get arrested for something new, or else a judge has the potential to revoke your bond, which is what I'm doing. So I'm going to leave this bond at $750. I'll have no requirement for bond on count 2. So that'll be a total bond of $750 on this case, but there's going to be a bond revocation on the other case to no bond.
Our office does represent Mr. Lee on that case, Judge. I'll let his public defender know what
Thank
took
you.
place this morning.
Okay, and it'll be no bond on all counts, so he gets gain time on...
He posted
not
bond
gain
on
time,
all.
I'm sorry.
He posted bond on all the counts.
Right. Okay, so it'll be no bond on all counts. Great. Okay, understood. All right, your public defender will reach out to you, okay, sir?
So I won't be able to bond out?
Well, you can bond out on this case, but probably not the best idea because you're going to be held no bond on your other case. So you might want to just sit tight and accrue some time while you're sitting there.
I'll have Mr. Johnston come see. I'll send him an email to come see you, okay, Mr. Lee?
All right. I have Jeremy Buonvincino. Medical reset. Okay. And I have Joseph Burnett. Medical reset. All right. I don't have anything else. Is there anything else I missed? Nope. Okay. I think we're clear at all the jails. Okay. We'll do this again at 1:30. Mr. Linder, do you want this back? Or do you want me to toss it? This is that one case with the...
Your Honor, can I just have a couple minutes to write this order?
Yes, of course.
Thank you.
Of course. Sorry about that.
That's okay. Okay, that's why I wanted you to check, because I don't want to get up and say, no, he's, you know.
And just so you guys all know, I have a county civil meeting starting at 1 o'clock. I'm going to do my best to get out of there as soon as I can to be able to start on time, but just kind of understand. Yeah. I think it would be, it's not a willful failure to appear. Trey, you can talk to Judge Lee about that.
I was going to say, tell Judge Canner to move it along.
Oh, no. Listen, if it was Judge Canner, forget it. I wouldn't be here until 3 o'clock. Judge Lee, though, is running the meeting, and so he is much more...
No,
he will be much more succinct than Judge Canner could ever dream of being.